This video is called Inside the 1% Legal Fortress, explained step by step. And in the next 60 seconds, I'm going to show you why the rich stay safe, why the average earners stay exposed, and the exact framework the 1% quietly use to keep their wealth out of reach, even in the middle of a lawsuit. And I'll warn you now, once you understand what I'm about to show you, you'll never look at your own financial life the same way again. I'm Kevin, the business guy, the CEO of Lawyers Limited PLLC, a law firm that specializes in asset protection, and our brand, Asset Protection Planners. And for 34 years, I've specialized in protecting high net worth people from lawsuits. For nearly 30 of those, I've set up Cook Islands Trusts, and our firm has set up more Cook Islands Trusts than any firm in the world. So let's get straight to it, no fluff. Let's open the vault door. Hidden fortress of the 1%. Most people assume the 1% are lawsuit proof because they're powerful, but that's not why. The 1% are lawsuit proof because they don't own the assets they control. That's it. That's the entire secret in one sentence. And in a minute, I'm going to walk you through exactly how they do it step by step, including the trust, the LLC, the control mechanisms, and what happens when the lawsuit actually hits and the legal machine turns on. But first, you need to understand the core problem. Wealth attracts lawsuits in a way that boats attract barnacles. You have more real estate, more business activity, more visibility, more people wanting a piece of you. A high net worth American has a 1 in 3 lifetime probability of being sued in a way that targets their personal assets. One wrong signature, one car accident, one disgruntled partner, one contractor dispute, and the wrong person can financially gut you. Meanwhile, the 1% sit behind a legal wall so thick that even winning lawyers won't try to climb it. And that wall isn't a secret offshore conspiracy. It's a legal structure fully compliant with U.S. law. But almost no one sets one up in time, and we'll talk about timing later because that's critical. Before we go any deeper, quick housekeeping. If you're serious about learning this stuff and you really want more content like it, go ahead and subscribe now. Please check right now to see if you are. I'd really appreciate it. I want to see you again. You want to have a guru to help you make money. You want to have a guru to help you keep it, because what's the sense in making it if you lose it all in a lawsuit? I keep it educational, insightful, and extremely practical. No hype, just strategy. All right, let's go ahead and go deeper. Let's talk about why wealthy Americans are lawsuit magnets. And I say America, but we work with people all over the world, people all over the country and all over the world, Canada, UK, Australia, New Zealand. Wherever you live, most likely we can help you. So if you want the 1% playbook, you need to understand the battlefield. Here's the uncomfortable truth. Your net worth determines how attractive you are to a plaintiff's attorney. If you're worth $250,000, you're not interesting. If you're worth $2.5 million or more, you're very interesting. If you're worth $10 million plus, you're a walking billboard that says free money here. The U.S. legal system allows contingency fees. Lawyers can sue you for free and keep 30 to 40% of whatever they win. So if you have something to take, someone will try to take it. Real estate, fair game. Brokerage accounts, fair game. Business interests, fair game. Future income, fair game. Your personal residence, often fair game, depending on your state. Your bank accounts, definitely fair game. You may think you're protected because you have insurance, but ask any real attorney and they'll tell you insurance is a payment method, not asset protection. You see, insurance pays lawyers to fight. Asset protection makes you unprofitable to sue. There's a big difference between winning a lawsuit and being unappealing as a target in the first place. And wealthy people understand the difference instinctively. Okay, here's the real secret: control versus ownership. So here's the principle the 1% live by. If you own it, they can take it. If you don't own it, they can't do that so easily. So that's the entire game. Most Americans have everything in their own name: their house, their rental properties, their bank accounts, their investments, their business, their partnerships, their toys, everything. They're walking around completely exposed. On the other hand, The wealthy separate themselves legally from the assets that make them wealthy. They use structures and usually multiple layers. A trust, an LLC, sometimes a second LLC, and sometimes a lien or multiple liens, and sometimes a special purpose entity, often across jurisdictions. Sound complicated, but I promise you it's not. In fact, I'll show you the entire thing in a single diagram in a moment. But first, I want you to hear this line. The 1%, remember this, the 1% don't hide assets. They relocate them into legally protected structures. There's no secrecy. There's no shadiness. It's legal architecture. Okay, first up, the Cook Islands trust structure step by step. Here's the part wealthy people pay tens of thousands of dollars to learn. How does the legal fortress actually work? Let me go ahead and walk you through it slowly in plain English because, like I say, we've set up more of them than anybody in the world. Step one, the Cook Islands Trust. That's the foundation. A Cook Islands Asset Protection Trust is a trust formed under the laws of the Cook Islands, a jurisdiction known for having the strongest asset protection trust laws in the entire world. Key points. U.S. judgments or judgments wherever, whatever country you're from, are not recognized. To attack the trust, somebody must sue in the Cook Islands. Plaintiffs must pay their own legal fees, win or lose. The standard of proof is beyond a reasonable doubt. The criminal standard. Contingency fees? Illegal. Fraudulent transfer claims expire in 1 to 2 years, depending on the circumstances. So this is why the wealthy use it. It's not because it's offshore. It's because the laws are better. Step number two, the Cook Islands LLC. And that is owned by the trust. So the C-I-L-L-C. Okay, so that's owned by the trust. That's why it's inside the trust here. So the trust owns 100% of it, but you, the client, okay, here's your smiley face here, are the initial manager of the LLC while things are calm. That means you control the bank account, you control the investments, you keep full access, you operate as normal. The money is protected, but your lifestyle doesn't change. Step number three, asset placement. So put cash, crypto, other assets inside of this LLC that's inside the trust. Now, we use an offshore bank in some of the safest jurisdictions like Switzerland so that U.S. courts do not have access to that bank account. Real estate stays in the U.S. naturally because it's pretty hard to move that. More on that later. But we protect it with a different technique called equity stripping, which I'll explain to you in a few minutes. Okay, now the trigger clause, and this is the magic. Your trust has a built-in legal pressure valve. When a lawsuit strikes, when the waters get rough, your licensed bonded Cook Islands Trustee Company law firm steps in temporarily as the manager of the LLC. So here's a bunch of people here, like a bunch of attorneys in the firm, and they step in as manager of that LLC. See their smiley faces because they know they can help you. There we go. So that's you. And that's the trustee. And that's the trustee company. So you step out, they step in. You're still the beneficiary of this trust here, so you still have access to the funds. All you have to do is ask, but your enemy at law does not. So in this case, your assets go into maximum protection mode. So this isn't optional. It's mandatory by law, and it's the cornerstone of the system. It removes you from control the exact moment this becomes dangerous. It protects the trust. It protects you. And ironically, it protects the trustee, which forces them to protect you aggressively. Okay, step number 5, a lawsuit hits. Walls go up. If a creditor tries to go after assets in the trust, they face foreign jurisdiction, foreign court, no contingency lawyers, no fee shifting, no U.S. judgment enforcement, the highest burden of proof in civil law. No plaintiff's attorney wants to fight that. So that's like showing up to a gunfight with a kazoo. Okay, so what happens when a lawsuit actually strikes? Let me pull back the curtain so you can see real mechanics. Most people think lawsuits work like the movies. You get sued, you hire a lawyer, you go to court. Nope. Most lawsuits end in threat letters, aggressive negotiation, pre-trial pressure, discovery requests, asset research. And here's what they're really looking for. Are you worth suing? And if the answer is yes, they proceed. If the answer is no, they walk. A Cook Islands Trust with a Cook Islands LLC turns you into a hard no. And here's the cliffhanger that I promised earlier. In about 2 minutes, I'll show you 2 2 anonymized case studies where the plaintiffs walked away from multi-million-dollar claims once they discovered the trust structure. But first, let's talk about the most misunderstood part. Composite case studies, and we'll talk about some real outcomes. Case study number 1, the surgeon with the $3 million nightmare. A surgeon faced a malpractice lawsuit demanding over $3 million. Now, he had good insurance, but the attorneys also wanted his personal assets. They blew right past the insurance funds. Before the lawsuit, he had set up a Cook Islands trust here. Liquid assets were in the offshore bank account. His real estate was liened with equity stripping. So we take the, let's say, a house here. Okay. Remember that Cook Islands LLC, C-I-L-L-C, that's inside the trust. We take that and we record liens against the property. Okay. And then if needed, we get a third-party lender to purchase those liens and then put the proceeds into your offshore trust structure. That way the assets are fully protected and you got a third-party lender involved. So his real estate was liened with equity stripping that we set up for him. Now, he appeared broke. And after seeing the structure, the plaintiff's attorney withdrew their demand and settled for the policy limit. So our client never touched his savings. Case study number 2. The investor with $10 million in rentals. Another client had millions in rental properties. One property had a tenant claim injury and a suit after a fall. The attorney ran his asset search. Properties leaned to the hill. Cash, offshore. LLCs, layered and protected. Trust in the Cook Islands. And they settled for a fraction of the claim. So why? Why did they settle? Because there was no realistic payday. And that's where we want to set you up so you can be in the same position. This wasn't magic. It was law. Okay, here are the fatal flaws of domestic asset protection. People try to use domestic trusts and so on. Domestic trusts sound good. They're promoted like they're good. States like Nevada, South Dakota, and Wyoming market them heavily. But here's the problem, and I've seen this over and over again. Domestic trusts are governed by U.S. judges who can be influenced by U.S. politics and U.S. litigation, U.S. pressure. And if there's a conflict between state law and U.S. constitutional law, the Constitution wins every time. If a judge wants your assets, they can order you to bring them back. If you refuse, you're in contempt in a domestic trust. And contempt is powerful. It's unlimited. A judge can hold you until you comply. So that's why the 1% don't rely on domestic trusts. So here's the rule the wealthy people follow. If a judge can reach you, the judge can reach your assets. And this is why if you have control, or if it's in the U.S., or if it's a trustee is within the judge's reach, they can reach the trustee and order them to hand over your money. So this is why offshore layering structure works. When you're not the manager, the assets are not in the U.S., and the judge cannot compel you to bring them back. You can't bring them back. You don't control them in that moment. And that's the entire strategy. You can still get the assets anytime you want to. Just ask the trustee. And like I say, we set up more of these than anybody in the world. And the trustees are licensed, bonded, trustworthy. We've never seen anything but perfect integrity. I've been doing this for 30 years. So here's the 1% playbook for a lawsuit-free life. Let me give you the distilled formula. The same one I teach clients $10 million, $20 million and up. Step number 1, move liquid assets into the Cook Islands LLC. Okay? And this LLC, again, is owned 100% by the Cook Islands Trust. So why do we do that again? It just gives you a tool inside the trust that you can control while the waters are calm. And when things get stormy, our trustee company and law firm can step in to do what you paid them to do, and that's protect your assets. Okay? Number 2, equity strip U.S. real estate using liens. It's equity stripping liens. There's the real estate. Equity strip the real estate. So that way there's no equity, nothing to take. So we record mortgages, initially, like I say, payable to the Cook Islands LLC. Then if needed, we can sell the mortgages to third-party lenders that we have access to. We can help you get this money moved offshore, deposit the proceeds into your offshore protected structure. Number 3, we title real estate inside of land trusts. So we have a land trust here, and the beneficiary of that land trust is an LLC. It's your personal residence. We just use a land trust. It's in a different tax category, and that's how we structure it for privacy purposes. So the LLC adds protection, and the land trust provides you with privacy of ownership. Okay, number 4, keep the offshore trustee on the sidelines. You operate normally until legal pressure hits. So when a lawsuit hits, the trustee company can step in as manager of this LLC. It's several attorneys on staff here, and that's trying to draw a tie there. And they become manager of the LLC. Temporary, legal, mandatory. Assets move behind maximum walls. Okay, number 6, when the danger is gone, this string of control that the trustee has, they're still trustee of the trust, but they remove themselves as manager of the LLC, and there's your smiley face again, back in the driver's seat with all of your assets intact. So the waters are calm, you step back in as manager, and life goes on. So this is the structure the wealthy use. I'm giving you the playbook here. So this is the structure we've built for tens of thousands of clients, and this is the structure that has beaten lawsuits for almost 40 years. So final takeaway, let me land the plane. The reason the 1% stay lawsuit proof isn't luck, it's architecture. They have structure, not hype. Control, not ownership. A strategy, not reaction. Protection, not insurance alone. So if you want this kind of legal fortress, one that stands even when the legal world is trying to break through, go ahead and go on over to assetprotectionplanners.com. It's a brand of our law firm, and we've protected more wealth in the Cook Islands trusts than any firm in the world. And your future self will thank you. See you next time.